It is Saturday afternoon at the annual spring meeting of the American Bankruptcy Institute. I am Bill Rochelle, ABI's editor-at-large. Sitting with me now is Deborah Williamson, partner from Dykema, Cox & Smith in San Antonio. And I have a suggestion. If anybody out there is involved in an oil and gas case, you better hire Deborah. Because if you're a Yankee lawyer and you've never encountered oil and gas law before, you may commit malpractice in the first 5 minutes. Deborah has been spending her entire life with the oil and gas business because that's what Texas lawyers are called upon to do. And she has recently committed a part of what she knows to this book right here, When Gushers Go Dry, published by the American Bankruptcy Institute. It is a magnificent handbook on oil and gas law as it applies to bankruptcy. And surprisingly, that's exactly what I want to ask Deborah about right now, is problems arising in the spate of oil and gas cases that we have recently because, frankly, the big money, big dollar cases in bankruptcy court these days in reorganizations are oil and gas. They've even overcome coal in terms of size and frequency. So, Deborah, tell me, what is a major problem area that is arising in these newly minted oil and gas cases?
I think the issue that probably creates, shall we say, the most opportunities, particularly for unsecured creditors, and the greatest risk for secured creditors, are issues surrounding extent and validity of perfection of liens.
Now, why is that a problem? Because in an ordinary commercial Chapter 11 case, getting a perfected lien is as easy as falling out of a tree. You file a UCC financing statement, maybe you have to give notice to a bank or something, that's it. Why is it more difficult in oil and gas?
Well, for two reasons. One, the nature of the collateral will change. For an example, you may be a lender to an E&P company, and they may be a
E&P means
exploration production, the ones who do your drilling.
I'm a Yankee now, so you got
you got Texas roots, Bill.
You have to use English for me.
Yeah, you've got Texas roots, I know. A company that does the drilling. So you may be a lender to a company that does the drilling, and they may have a contract that will allow them to drill and earn acreage. Well, that contract, that farm-out agreement, we perfect farm-out agreements, contract rights through UCC. But once they've earned that acreage, then it becomes a real property interest. How do you perfect a security interest in real property? You've got to go file your documents in the county where that real property is located. And then once there's production, and so you've got the oil and gas severed, it becomes personal property again. And then from personal property, it turns into accounts receivable, and again, you have to perfect different. And then when it becomes cash, well, you need to have a deposit control agreement for the account where the cash is deposited. So unlike a lot of situations, your nature of your collateral can change very quickly over a period of 20 or 30 days. The other issue that you have is that oil and gas companies are constantly acquiring assets and selling assets. So you may have thought that you had a perfected lien on lease A, but they farmed out their rights on lease A, but they bought lease B. Maybe in the same county, maybe not in the same county. Have you filed additional lien perfection documents on lease B? Sometimes they have, and sometimes they haven't.
Well, wouldn't a lender be protected by a clause in a loan agreement which says that basically all of your assets have got to be pledged to us? Doesn't that work?
So here's a secret, Bill. Sometimes borrowers don't keep their promises. And I know that's hard for people to believe out there. All that is, and you see it fairly frequently. There's a covenant that the borrower agrees that at all times they will pledge 80 or 90% of their producing properties. It's nothing more than a promise. The fact that they've promised it to you, but if you don't have a perfected security interest in it, you go to bankruptcy court, the court's not going to recognize your lien, unfortunately. Promise was broken, and you are now not perfected in that asset.
Well, what about farm-out agreements? What is a farm-out agreement, and what are the issues involved, and what should lenders be doing or creditors be looking for in terms of perfection there?
So a farm-out agreement, in its most basic terms, is Party A has a lease and has a lease and the right to drill on that particular lease, that particular acreage, but decides to kind of offload the risk and contracts with Party B to actually drill one of the wells on the lease. And when that Party B drills the well, Party B earns an interest in that well, in that lease, and surrounding that well. And those are called a farm out. Party A farms out to Party B the right to drill and the right to earn an interest in it. And the bankruptcy code actually recognizes the rights in a farm out, even though it's not recorded, which is, we all know, very unusual. But the problem for the lender's perspective is that they may not know that Party B is a party to a farm out agreement and is earning rights and earning property and property interests. And if they don't know that, then the odds are pretty good they didn't perfect the security interest in it.
Well, so this means that lenders in the oil and gas industry have got to be particularly vigilant, don't they?
Absolutely. I mean, and that's one of the, and now let's make it understand some of the nature of this. A company may have hundreds, if not thousands, of leases. It's not at all unusual to have, like I said, well files and lease files that are very complicated. And then to make it even more fun, most E&P, most drillers, they keep their records by well because that's where they're spending their money, that's where they're earning their rights, that's where the production comes from. But you perfect by lease. And you may not, and a lender, not only do they have to know where the money is being spent, what wells it's being spent on, you also have to know what lease it's in so you can go perfect your security interest in the lease. It's very difficult, or can be difficult for lenders in a distressed, dynamic economy to stay on top of what their borrowers, their E&P customers are doing.
Oh dear. Well, assume that a lender comes in and retains you because they have a borrower who is in distress, not in bankruptcy yet, in distress. So there is some time to make amends for prior sins. What would you have the lenders do in terms of their collateral?
And oftentimes is of the essence when you're dealing with this, because you have competing liens that could come in from the trade creditors who are providing services. So when time is of the essence, what we do is we ask them to categorize into two groups. We're going to triage your perfection or your security interest. Group one is where the debtors are telling you they're going to spend their money, where they're going to spend their money in the future. You certainly want to make sure you've got a perfected security interest in any leases where CapEx is going to be spent, where cash will be spent. The second category is, where's your money coming from? Where's the production? And we ask them to rank highest production to lowest production. Let's make sure you've got a perfected security interest where the money's coming from. So where the money's going to be spent, rank those, and where the money's going to come from, rank those, and then do your due diligence and make sure you're perfected running it down that way.
You know, this is very interesting, Deborah, because I've heard over the years from people who purchase bonds in the secondary market that there is always going to be gaps in terms of the rights of the lenders that you really can't determine from public filings, which is very often, if you're coming in the secondary market, the only thing that you've got to determine how good the collateral is, for instance. Mm-hmm. But it seems to me that it is particularly perilous if you have an oil and gas loan and you're coming in to buy a piece of that loan, especially if it's out of a public market. Maybe if you're in a private sale, right, you might be able to find what the seller knows, but even then, I guess, it's a problem, isn't it?
Absolutely. I mean, in theory, the only way to actually know whether or not there is a lien on a particular lease, first of all, you have to find out what leases they have, what leases the debtor or the borrower owns. There's no record, at least in Texas. We don't keep our real estate records, so you can easily go and say, oh, Bob owns all of these. So first you got to find out what they own, and then you got to go check and see where liens timely and correctly filed, where the description's accurate, and when were they filed, and are there intervening trade debt liens that came in. It's very difficult. And that's part of the job, part of the job of the lender is to really stay on top of this and and do what they can to have a full database of information. And if you're going to buy into a loan position, particularly if you're doing it on the private market, less so in the public market, if you're doing it in the private market, you want to know what due diligence has been done by the lender on an almost weekly, if not monthly basis.
And I suppose also this means there is particular importance for DIP lending, so that some lender, can sop up collateral that has not been properly perfected.
And that is exactly right. If it is one way to come in to be a DIP lender, and you take a security interest and everything. One of the problems with that, though, of course, is if there was intervening trade liens, then it's more difficult for the DIP to trump those. But at least it gives you an interest in the property you might have missed in the pre-bankruptcy
And
days.
I gather lawyers like you representing creditor committees are starting to learn that improper perfection is a big deal, and you ought to try to prevent those issues from disappearing up front in the case?
Absolutely. It is one of the issues that I think you will see in every case where they're going to come in and have an adverse impact on the trade. That's the job of the trade. And for those who are new to oil and gas lending, let me assure you that the trade creditors, they've been doing this for a very, very, very long time. They know how to perfect their liens. And as I said to somebody, they only have to find a breach in one wall one time. You as a lender have to be defending all the walls, every security interest you take. They just need to find one.
Well, my instinct tells me that oil and gas bankruptcies are not going to go away. So, Deborah, I think about a year from now, we'll come back for part 2 and see how the courts are progressing with the spate of energy bankruptcies we have today.
I look forward to talking with you next year on what we've learned over the last year.
Well, let's
Bill.
stand adjourned for a year.
Thank you.
Good.
It worked.
Excellent.
Thank you.
There might be a spot at table.